She grabbed my hands and she said, Google hypothermia, Google how long it takes to die in the cold.
You see this first search that says how long to die in cold?
I do.
What's that time?
Well, the search was how long to die in cold, and it happened at or before 2:27 a.m.
The infamous Google search, how long to die in the cold, at the center of an important hearing today. This is in the case against defendant Karen Reed over the murder of Officer John O'Keefe. We'll go live together to that Massachusetts courtroom. And defendant Sean Diddy Combs is now facing a superseding indictment with 2 more female victims and accusations of violent behavior, including dangling someone from a balcony. Also this hour, we're spotlighting what is next for defendant Natalie Cochran after a small-town jury quickly condemned her to life in prison. Now, considering all of the evidence, what are her chances on appeal? We'll talk about it. Plus, the troubled past of a mother could be tipping the scales of justice in her son's murder case. We'll talk about what the testimony is revealing about Collin Griffith's mom, Kathy. It's all coming up next for you right here on Opening Statements. Good Friday morning to you, my friends. Welcome to Opening Statements. I'm Julie Grant. Are you ready for what I like to call some coffee and some court? Go ahead, grab that coffee right now. We got a great show planned for you, and it's time for my opening statement. There's strength in numbers, and the number of alleged victims are increasing in the criminal case against defendant Sean Diddy Combs. Federal prosecutors have filed a superseding indictment against him, adding 2 more victims and 2 new, very disturbing allegations. One of which is that he dangled a woman over a balcony. And if that sounds familiar, it should. We've talked about this before on this show. There was a lawsuit filed by Cassie Ventura's friend, fashion designer Brianna Bongolan. Now, could she be one of these second 2 victims? Quite possible that she is. The federal indictment doesn't name names, but in knowing the facts, it's always seemed like victim number 1 is Cassie. Which brings me to the other brand new sickening allegation. The federal government has revealed that Diddy and his associates bribed the hotel security staff with $100,000 for the video of his brutal attack on her. Now, if that's true, they should all be fired. And if that video didn't become public, think about it, my friends. I don't think we'd see Diddy being prosecuted. Thank goodness someone was brave enough to release it. And thank goodness these 3 victims have so courageously come forward. The diddler, as they call him on TikTok nowadays, was once seemingly untouchable. But a new day has dawned, and voices of alleged victims are now being heard. So now, if Diddy were to sing his famous lyrics about "can't nobody take my pride, can't nobody hold me down," the federal government would beg to differ. That's my opening statement. Let me know if you like it. Right now, it's time for your daily docket.
And you're also aware that Kathy had been arrested before?
Yes.
Specifically for an incident that involved her stabbing her then husband in front of 10-year-old Collin.
Yes.
We've got testimony resuming this morning in Florida in the deadly son murder trial for Collin Griffith. That case starts up at 8:30 a.m. Eastern Time. In California, we've got the state's case resuming at noon in the celebrity hairstylist murder trial for defendant Monica Cementilli. And in Michigan, we've got the mother of the Oxford High School shooter, Jennifer Crumbley, back in court for a motions hearing. And get this, she's demanding to be released from prison while she waits for her appeal. Court starts up at 9 a.m. in that one. We'll keep you posted on all of these stories. Right now, let's turn to our top story we have for you this morning. Defendant Karen Reed will be back in court this morning ahead of her homicide retrial. Special prosecutor Hank Brennan is asking to bar a key defense witness from the case because that witness's opinion has been scientifically debunked. You'll recall at the first trial, the defense team called a cell phone expert named Richard Green, and he testified that it was his opinion that Jennifer McCabe Googled how long to die in cold hours before John O'Keefe was found in the snow.
We found a Google search that happened. First of all, the search was "How long to die in cold," and it happened at or before 2:27 a.m.
In what state did you find that artifact?
Yeah, so the specific artifact, or it comes from a record, and the record number on this is 4028, I believe, and it was in a deleted state.
Okay, so Jennifer McKay was Googling basketball scores at 2-something in the morning. And when she pulled up that page, the same Google page where she searched for the score, to do the search at 6:24 a.m., How Long to Die in Cold at Karen Reed's direction, the company Cellbrite has said that that data was misinterpreted. It was the page time, not the search time. So what did Cellbrite do? They actually changed their software in response to this case and Richard Green's inaccurate interpretation. So now no one will ever be able to misinterpret a search from opening a page at a certain time. So what does this mean? Well, this morning there's going to be a hearing about it because the defense still wants the jury to hear Richard Green's opinion. So let's talk about what the rules of evidence say about that. I want to bring in now two very special guests, criminal defense attorney and former prosecutor Joe Krowski, and he practices in Massachusetts and in this jurisdiction where this case is being tried. And want to welcome in the creator and the host of Road Patrol Live. He's a nationally known radio host, very popular on social media, Mr. John DePietro. Good morning to you both. Okay, so Joe Krowski, I want to turn to you first.
Yes.
With the rules of evidence. When we think about what experts can testify to, the rules talk about how expert opinions can assist the trier of fact. If it's something that can assist a layperson in coming to a proper conclusion, that could come in. But the rules say if it could lead to misleading a jury or confusing the issues, the opinion should stay out. So tell me, knowing the rules, Joe, what do you think the court ought to do now that this opinion has been debunked by the company of the program he used to analyze it?
Good morning. First, if you don't mind, I'd just like to say God bless those victims and their families in the aviation accident that hit close to home in Massachusetts. As a matter of fact, the Boston Skating Club is a town away from the Dedham Superior Courthouse. So I hope you don't mind me wishing my heartfelt condolences to all of those people.
We feel the same way.
So look, typically the subject matter is something that is typically put before a jury. Forensic interpretation and testing of cell phones and computers is fairly germane to these cases. What the Commonwealth is saying is that they understand and appreciate that you can have a battle of opinions, but here there is no legitimate opinion that Green has. And it's pretty remarkable. I read the submission from the defense. Green makes interpretations, but his interpretation seems just to be running it through a program and interpreting the data. He does absolutely no testing. So if I'm interpreting the Commonwealth's motion correctly, it's that there's no methodology laid out. And before it can go before a jury, his methodology should be put to the test pursuant to both federal and state law. So judges want defendants to have robust defenses and be able to present their proofs. However, you can't just say anything. And I think where Green loses some significant credibility is the implication of his affidavit is that the data, the hash values, could have been manipulated. There's probably only a handful of people in the entire world that have the wherewithal to go in and manipulate hash values on software. And I also don't think Cellbrite would be putting the imprimatur of their company behind their senior analyst if they weren't 100% on board with Ian Whiffin's opinion that this search did not happen until after 6 in the morning. Also, from a common sense perspective, Jen McCabe didn't go home and Google something about her daughter's basketball league sitting in bed and then decide to also make a Google about how long it will take John O'Keefe to pass away in the front lawn. So I think Hank Brennan is attacking prior to trial any of the expert testimony related to the conspiracy theory, which he in good faith does not believe is legitimate.
Right. And Hank Brennan is a monster trial attorney. I mean, as solid as they come. I said when I was watching him, I said he ought to teach trial advocacy. He was so precise. It was textbook what he was doing. And then I looked him up, and he does teach. Apparently, he is an adjunct trial ad professor, too.
Yes.
And so surely shouldn't surprise anybody. Joe, when we also think about this defense pushback on wanting Richard Green's testimony in, what I can't understand is that they want it to come in, but they don't want to have one of those hearings like we saw a couple of weeks ago with their other witness, Dr. Marie Russell. They're saying to the court in their motion that we want Richard Green to testify, but we don't want to have a Daubert hearing. Could it be because they don't want to have another match with Mr. Brennan?
Maybe it is that they don't like how it went with Dr. Russell, even though ultimately Judge Cannoni decided she can testify. She certainly is coming in as a scarred witness at this point, and the Commonwealth has an absolute trove of material, and that's probably where the objection comes from. Look, I don't fault the defense. They're doing their job. It's certainly a drain on their resources, and to their credit, it is a little unusual to have this type of hearing, but again, this is an unusual case. And what the Commonwealth is saying is this isn't a battle of experts giving different opinions. There is no subjective disagreement in the community. This search could not have happened.
Appreciate the analysis, Joe. So knowing what the legal rules say, we'll see what Judge Cannoni does today when she's going to hear arguments from both sides about whether we should even get to the point of a hearing. And while that's going on, of course, there's the story of Jennifer McCabe and where she fits in with the victim's family, the O'Keefes. And John DePietro, this is where I want to turn to you. You've really dug deep. You've talked to a lot of people on this case. You know a lot about it. What have you come to learn about Jennifer McCabe and her relationship with the O'Keefes and with our victim, John O'Keefe?
Julie, Jen McCabe, she was friendly with John's sister. One of her children is best friends with the niece of John O'Keefe. Jen McCabe, mother of four, fifth grade teacher. Her and her husband, Matt, very active in the community. They're the type of people you want, and they're a strength in a community. But Jen McCabe, Julie, it doesn't stand to reason, as Joe said. If anyone stands back, for her to be lying in bed wondering, gee, I wonder how long our friend, John O'Keefe, who she was the last one texting with, she was the one that was really friendly with John. She was the one, she had the good friendship with him. For her to be wondering, gee, I wonder if he's going to freeze to death on my brother-in-law's lawn, it just doesn't stand to reason. Jen McCabe was also the one that when John O'Keefe's sister tragically passed away, her niece spent a lot of time at Jen McCabe's home. Jen McCabe also lost her mother when she was at a young age. It is brutal what she has gone through. But this is the cornerstone. I would argue, Julie, this is the cornerstone of the conspiracy. They've had merchandise, they had a billboard, they had T-shirts. This is what convinced a lot of people that this Google search at 227 had happened. And I believe, Hank Brennan has really torn it apart. Anyone that's objective will see that there's no way, and this was a confusion the defense put forward with Richard Green.
Great points, John. And going back to the story when we remind ourselves and refresh our memories, because it's been a while, correct me if I'm wrong, but it was Karen Reed who frantically had John's niece call Jennifer McCabe in the middle of the night. Karen Reed didn't have her number, but John's niece did because of that close relationship that you just described. And it was the first time Karen Reed changed her story was with Jen McCabe, was it not? She initially said, I dropped him off at the waterfall, haven't seen him since. And then Jen said, no, I saw your car outside of 34 Fairview.
That's exactly right, Julie. And then Karen Reed began to, try to piece together and come up with a different story. This is also, I think it speaks volumes that both Jen McCabe and Kerry Roberts, this is in the middle of a blizzard, it's freezing out, early morning hours. They drop everything to go with her, to look for John O'Keefe. But make no mistake about it. Jen McCabe, Julie, there's no way. They were a cornerstone. John O'Keefe, in raising his niece and nephew, they depended on people like Jen McCabe and Matt McCabe and people like that saw that this was a guy trying to do the right thing. And how many times, did their did the niece stay over at their home? And they were always trying to, be helpful to him. So the idea that they somehow took part in this conspiracy, this hoax to actually take his life, it just isn't plausible. And I think Hank Brennan will diffuse the confusion that Richard Green has put forward.
I think you're exactly right, John. That's a great prediction. We should see it this morning, perhaps as soon as this kicks off, and appreciate the insight, because the attacks on Jennifer McCabe have been disgusting, unwarranted. She's a witness who did a good deed. And like the old saying goes, no good deed goes unpunished. Everyone that I've spoken to, and I haven't spoken to nearly as many people as you have, John, who knows her, knows of her reputation in the community, it says what a lovely woman she is and what a loving person, and that these attacks are completely unwarranted and unfounded. John DePietro, I know we're going to talk again, my friend. Thank you for making time for us. My friends at home, be sure to follow John with Road Patrol Live. It is an awesome show. You're going to love it. And we'll see you after this hearing, John. And Joe Krowski, you're going to be coming back with us for the hearing. I'm so excited to have your legal analysis live as we dig in together here on Court TV. Coming up next here on Opening Statements.
Natalie Cochran is the face of evil. It appears all to be good on the outside, but what lies on the inside is pure evil.
No mercy granted for convicted killer Natalie Cochran. We're looking ahead to the possibility of an appeal. But first, the downfall of Diddy continues. The music mogul facing brand new, disturbing allegations.
Grieving widow or mastermind behind a murder.
Monica Cementelli is accused of plotting to kill her husband.
Famed celebrity hairstylist Fabio Cementelli.
Prosecutors say she and her lover killed Fabio to collect a big life insurance policy.
The defense may say she's a bad woman, but she wouldn't be involved in a murder.
It's a whodunit Hollywood story, but will there be a twist that no one sees?
The celebrity stylist murder trial, today, only on Court TV.
Combs did not do this all on his own. As I mentioned, Combs has been charged with RICO conspiracy. He used his business and employees of that business and other close associates to get his way.
The sex trafficking case against defendant Sean Diddy Combs is what's trending in true crime. The superseding indictment filed Thursday doesn't contain new charges, but it is filled with new accusations of criminal behavior, including claims that at least 3 women were forced to engage in commercial sex acts, and that Combs on one occasion dangled a victim over a balcony for threatening his authority. That's the allegation. Now, the statement was issued on behalf of Combs by his attorney, Mark Agnafilo, saying in part, the prosecution's theory remains flawed. The government has added the ridiculous theory that 2 of Mr. Combs' former girlfriends were not girlfriends at all, but were prostitutes. The statement goes on to say Mr. Combs is as committed as ever to fighting these charges and winning at trial. Okay, so the defense doesn't seem too concerned, but we got a different indictment now, slightly different. So how is that going to change things at trial? Let's bring in our legal eagles now. With me, attorneys Don Malarsic and David Bruno. Good morning to you both. Don, let me start with you, please. How do you think this is going to affect things?
Well, you see these superseding indictments as the government's case progresses, and usually it's a telltale sign that somebody is cooperating, right? Somebody has decided to flip, to resolve their case and cooperate against Mr. Combs. The government then goes back and they adjust the indictment. They add details that they know that they can prove through credible, reliable evidence and cooperators. So this is a tough sign for Mr. Combs and his defense. I suspect that as people get involved in this case and they become targets and defendants and they meet with their defense lawyers, they're trying to get a way out. And their way out is offering cooperation and testimony against Mr. Combs. And it feels like that's exactly what's happening here.
Sure does. Great insight, Don. David Bruno, to you next. Your thoughts, please.
Yeah, I agree also. Look, the soundbite of the U.S. attorney also started with, Combs didn't do this on his own, which is a telltale sign of cooperators. I'm wondering, when's the ball going to drop to everybody else? Is he the only one? No. We know that from the statement. We know this from the reporting. We know this from the civil complaints. Why in the world is it just Combs? You know what also this doesn't have is the witness tampering, which I'm a little bit surprised of, because we were getting reports about the jail correspondence and the use of that attorney file that allegedly was attorney-client privilege, and there was word of in a grand jury on that. So it looks like maybe that ship has sailed. But with this, it also expands the time. It brings the conspiracy back 4 years, the racketeering back 4 years, and also adds other facts to support the racketeering. So what it really does is it expands the scope of relevant evidence. And that's going to be one of the jobs of the defense attorney, is with motions to try to bring it back in. And the statement we got from the defense attorney was, well, these were girlfriends. These were not prostitutes. And it does require commercial sex acts for value, and also the force, coercion, or threats of force to cause the victims to engage in the commercial sex acts. So I think that's where the defense is going to be coming to try to rein it in, while the government is also trying to expand the evidence that they're able to present.
Right. Great points, David. And thank you for noting that about the time frame expanding. In the first indictment, it was 2008 when the government was saying it all began. But then in this new superseding indictment, they're going back to 2004, as you noted. So thank you much for that. We'll leave it here for now, but we'll continue the conversation about Diddy as this case progresses. Both sides saying it should stay on track for the May trial date, and Court TV will be there. Now, let's turn to a trial that we're at as well in California, the felony assault trial for hip-hop star A$AP Rocky. The alleged victim, Mr. Terrell Efron, or his stage name, A$AP Relly, because remember, he was part of that A$AP collective with Rocky. That's how these two are friends and know each other professionally as well. He's set to come back for more cross-examination on Thursday. If you saw it, you know how heated it got when Rocky's attorney, Joe Tacopina, went after him. Take a look at this clip where he's crossing him on his lavish lifestyle.
It's important to you that you portray a very lavish lifestyle, right, Mr. Efron?
No. Would you repeat the name is Relly what?
Relly Boss.
Boss.
Boss. Like you, Boss.
Why don't you show on my Instagram? I'm already getting death threats. Because you're saying I'm extortionist and all of this, and you're putting my whole life on. This is getting really annoying.
No one is calling you an extortionist. You're going to get, Mr. Efron, you're going to get through a lot faster if you just answer the questions.
This was one of the messiest crosses I've ever seen. The judge would have to stop them, take a break. This was getting so bad. This witness at times very combative. At one point, I remember I saw him answer a question, yes, no, I don't know. And I loved Joe Tacopina's response. He looked at the jury and he said, well, why don't you pick one for the jury? Is it yes? Is it no? Is it I don't know? Choose one, sir. I mean, he made him look so bad. So bad. I can't imagine what's going to happen today. So is there any hope for this case after that cross? How is it going to affect the trial? Are people still believing A$AP Relly? Let's talk about it. David Bruno, let me start with you this time on this one. Your thoughts?
Julie, this is the star witness. This is the one. This is the one that the government needs to prove the case. And they already have problems with the shell casings. I mean, that's the biggest, that's the not guilty in my mind. I mean, the fact that police were on scene of this shooting, there was no evidence of a projectile being fired. There was no evidence of a casing that left any evidence of it, and the victim shows up hours later and finds it and then reports it to the police. And then the witness has no idea why his Instagram stories are relevant, considering that this was there's text message trying to get money prior to going to the police. It is unbelievable. I had my doubts after the opening statement, and I heard what the defense's positions were, and then this cross-examination. If I were the government, white flag, dismiss, save the government, save the taxpayers time on this one, honestly.
I hear you, David. Yeah, and and the judge even gave him time to consult, with his lawyers about how to just answer properly and stop fighting with Mr. Tacopina. And I read that his attorneys are Ben Chu and Camille Vasquez, who we know represented Johnny Depp. They're civil lawyers, and they were. But I mean, the preparation with this guy to answer these questions, I was stunned at how it looked. Don, I want to get your thoughts. What did you think of this guy on the stand?
Yeah, this was just really a masterclass, Julie, in cross-examination. The defense attorney was patient, was deliberate, and was exacting and was devastating. I mean, the reason why we're going into a second day of cross-examination is because this witness just really couldn't answer a straightforward question. So the defense attorney did a fantastic job of just taking him down these different rabbit holes and showing the jury that he can't answer a straight, simple, forward question. His credibility's been destroyed. It's going to be a really tough second day. And it's just tough to rehabilitate him, even though he's got these great lawyers, because he can't get out of his own way. He's just denying simple questions. You know, is a lavish lifestyle important for you? And he says no. And the defense has these hundreds and hundreds of Instagram posts with him talking about his lavish lifestyle. So these are freebies. These are givings to the defense attorney. He's doing a fantastic job of being slow and deliberate and exposing the real issues with this witness's credibility.
Excellent points. And Don, I sure hope Joe Tacopina hears about your comments praising him, because that'll mean a lot, knowing that you teach trial advocacy and you're saying of what you saw yesterday from him was a masterclass. Thank you both for all of that. Stand by kindly for more questions, please, Don and Dave. When we come back, here's what we've got coming up on Opening Statements.
But we know the real Natalie Cochran, the thief, the liar, the taker of life, and the doer of evil deeds.
Will Natalie Cochran, I meant to say Natalie Cochran will be spending the rest of her life behind bars. Yeah, it's not a question anymore. But will she have any success on appeal? That is the burning question. And we got a live look for you at Florida right now, the courtroom where the deadly son murder trial is happening. We're asking the question, could victim Kathy Griffith's troubled past tip the scales of justice? Welcome back. This morning, we're shining a spotlight on what lies ahead for convicted killer Natalie Cochran. And it's looking pretty bleak. A day after a jury returned a first-degree murder conviction for her for the killing of her husband, Michael, the same jury gave her no mercy recommendation with her sentencing, meaning she's going to spend the rest of her life in prison without any chance of parole. And they did that after only 70 minutes of deliberations. So it's really not a stretch to say that the jury did not like Ms. Cochran. And we know neither did Michael's mom, understandably so. She spoke at Natalie's mercy hearing, and you could tell that it was torment for her.
She will try to blame my precious son Michael for her evilness and deceit. Natalie may even shed a tear or two, but we have now come to know that every word coming out of Natalie Cochran's mouth will just be another lie, and her tears will be fake tears trying to get sympathy from your court. Natalie is going to use Michael's children to get sympathy here today. Judge, please don't fall for her con. That's what Natalie does. She only cares about herself. She will use, abuse, and manipulate anyone to get in her way. But we know the real Natalie Cochran, the thief, the liar, the taker of life, and the doer of evil deeds.
You can just hear Michael's mother's anguish, can't you? Then on the other side of this, we heard Natalie's mother speaking in her daughter's defense, trying to garner some sympathy.
How old are you, ma'am?
77.
So, like your husband, even if this jury gives Natalie mercy, you may not be alive when she gets out, possibly in 15 years.
I don't look for that. My mother lived to be over 100, but I don't feel like I can.
Okay. So you're hopeful that Natalie might get out and you might be able to spend more time with her. Is that correct?
I'd love to be able to spend, I want to hug her. And the bailiff here's let me give her a couple of hugs, but I want to just hold her for a long time.
Now you can see how her mother's words made Natalie very emotional, but apparently did not move The jury, our team in the courtroom was watching them, and just like their verdict, their no mercy decision was quite swift as well. The formal sentencing set for February 25th. So what now? What's next? Well, her attorneys are promising that an appeal is coming, but we hear that all the time, right? We hear that just about every case from every defense team where there's a loss. Oh, we're going to fight this on appeal. But what is the likelihood of success? Let's bring in our legal eagles and talk about that. Still with me, attorneys Don Malarsic and David Bruno. David, I'll start with you this time, please. What are your thoughts about her being successful on appeal?
Not very good. This is a firm verdict. I mean, if anything, the conversation needs to be on this West Virginia law, this mercy law. Really, it's nothing like I've ever seen before, in a sense that the jury has the sentencing authority here. They're the ones that hear the sentencing phase. There's little guidance on the criteria. Typically, aggravating, mitigating factors have to be balanced and weighed by the court who sentences. And then there's only two options. One is no parole, and one is parole at 15 years. When I heard this, and I have been following this with you guys, I mean, she really had no shot because of the prior history. It reminded me a lot of the Murdoch case, where you had the theft coming in, and that was the motive evidence, and it was allowed in for the jury. And similarly, there's a Ponzi scheme that they were able to bring in, which really damaged her. While it was narrowly admitted for the purposes of motive, these juries, they listen to that evidence, they see her as a criminal, she took the money, and then the communication with the neighbor to get the insulin was essentially game over for Natalie.
I love the comparison you just made to Murdoch, David. I think what you just said, I think, really clicks for a lot of people about how the theft crimes were horrible and motivation for what was even worse, the homicide. So thank you for that. We know that this happened in a small town. We had our team in the courtroom with eyes on the jury the whole time, and they said it was very clear to them that this jury hated Natalie Cochran. Let's take a look at a clip together now. The defense team reacting to the guilty verdict.
I really have no idea what evidence this jury was listening to. I think that this is one of the cases where the defense, not having the burden of proof, proved its case probably beyond a shadow of a doubt as to how, when, what, and why.
Okay, it's very clear. The defense put up a fight. They put up a good fight. Want to acknowledge that they called two forensic pathology experts to refute the cause of death. They had their own legal theory that it was a steroid overdose, and they even had the victim's own children talking about how many pills he would take. So a valiant effort on behalf of Natalie Cochran, but the jury did not like her, according to everyone at Court TV who was watching closely. Don Malarsic, what is that like when you have, attorneys who are doing a great job? I'm sure you've been in that position where you're pulling out all the stops, presenting everything you know how, but you can just tell the jury is not liking your client, even though they may like you very much.
It's brutal, Julie. It's awful. It's rough. It's difficult, but it's common. And this is where the defense attorney really has to kind of anticipate this and find some ways to humanize his or her client and draw some kind of connection to the jury. And what I saw the defense do in this mitigation, this mercy hearing, was really just put up family members and friends. And my experience is jurors really get turned off by that, because you're basically begging the jury not to do something on behalf of a person they've just convicted. That's a really tough theory and theme to sell to jurors who just convicted your client in 2 hours. I mean, the gold for mercy and mitigation is something like a mental health issue, a diagnosis, substance abuse, prior untreated trauma. I assume that didn't happen here because we didn't hear any of that in the mercy hearing. So the jury is left with seeing this cold, calculating, intelligent, articulate, successful person commit these deliberate, intentional acts. And unless you can explain that part of it, I don't think the jury gets a reason for mercy.
Don, I love your analysis. That is really, really sharp. You know, when we were watching this yesterday, I didn't hear any legal analyst guests say that. What you just said about how the point in mitigation, I mean, my gosh, and this is what you do. You're known as one of the top defense lawyers in the state of Ohio. And when you do death penalty cases as frequently as you do, mitigation's your wheelhouse, right? You're right. There really wasn't true mitigation. It was like, hey, my aunt was there for me when my boyfriend broke up with me. Hey, she was nice when my dog died. Hey, I'm really going to miss her. And, she, wrote a nice devotion book from the prison. You're right. None of it had to do with trauma, mental health, anything that would negate the criminal intent. I love what you just pointed out there. She just may be one of those people who is, sociopathic. The behavior looks sociopathic to me, to just not care to take out your husband like that in order to protect yourself.
Someone shows you who they are, believe them.
Isn't that the truth? Yep. Dr. Maya Angelou said when they show you the first time, right, believe them the first time, right? Wise words. Okay, we'll leave it there for now with Natalie Cochran, but again, we'll be back in February for the formal sentencing. Don and David are sticking around. Please do the same. When we come back, we're going to Florida. We're talking about this young teenager. Is he a psychopath? Some seem to think so. What about his mom, though? The defense is implicating his mom. And are they going to tip the scales in their quest? And also, we're going to show you the courtroom in Massachusetts where we're set to go soon for the hearing in the homicide case for defendant Karen Reed. We'll be right back.
Tonight on Court TV.
I'm Vinny Politan. Welcome to Closing Arguments. We have a big hour ahead here.
Your deplorable actions are unforgivable.
The community still doesn't know how this Boston police officer died.
He can't prove one element of his case.
It was a dramatic day, a dramatic moment inside the courtroom.
What's happening here?
It's unreal. Let me show you exactly what happened.
Closing Arguments with Vinny Politan. Tonight at 8/7 Central. Only on Court TV.
What caused the bleeding? She got into a fight and she was giving me the knife and she fell on it. Where is the knife right now? And who did she get in a fight with? She gave at me that we got into a fight for a long time and then she got on top of me and fell on it.
That's what he says happened. Testimony about to get underway soon in the deadly son murder trial for Collin Griffith. This is a live look at the courtroom right here. Attorneys are handling some administrative matters at the moment. Jury's not in the box just yet. The state saying that Collin's mom, Kathy, is a victim of a brutal murder. They're saying this is a murder. There's no doubt about it. But the defense is claiming that this was a stabbing done in self-defense. And they're calling into question Kathy's past. Take a look.
So are you aware that Kathy Griffith had been arrested before for stabbing her then husband?
No, I'm not.
Are you aware that she was also alleged to have burned him with a terrarium heat lamp in that same incident?
No, I'm not.
Are you aware that Kathy Griffith was on videotape shown to law enforcement and a DCF investigator driving her car and pinning her then husband to the house, between the car and the house in front of her children?
I am not aware of that, no.
All right, so will Kathy Griffith's past behavior tip the scales in favor of her son? Let's talk about this. I want to bring in our legal eagles, David Bruno and Don Malarsic. Don, let me begin with you on this, please. So for anybody wondering, hey, wait a minute, why are we having the victims' past transgressions or bad behavior instances coming before this jury when it's her son who's on trial? What do you say to that?
Well, when the defense raises this issue of self-defense, the jury has to determine who's the primary aggressor. We saw clips of the 911 call where Collin is saying that there was a fight and she lunged at him with a knife and he was reacting and she fell on the knife. So when that issue is raised before the jury, a victim's alleged prior criminal activity, alleged prior acts of violence are relevant. The jury has to weigh that and decide who was the primary aggressor here. So I think it's they scored a lot of points, It's this imperfect self-defense, though. He's not really saying, I did it, I stabbed her, I did it, I didn't want to do it, but I had to do it because I was in fear of my life. He's saying she came at me and she fell on the knife. So it's going to be difficult for the defense to get the jury to believe, I think, that this is a true self-defense claim because of the statements of Mr. Griffin at the scene, because of the 911 call. But Kathy's past and her prior acts of violence are definitely relevant.
Professor, thank you for that. Right, going to his fear of her, was it reasonable based on what he knew about her? I've got another clip talking about Kathy's violent past. Let's watch.
And you're also aware that Kathy had been arrested before?
Yes.
Specifically for an incident that involved her stabbing her then husband in front of 10-year-old Collin?
Yes.
David Bruno, do me a favor, hearken back to your time as a prosecutor. Think about it, you're in this case. These instances are coming in before the jury. They're going to consider these when they decide all of the issues. How concerned are you really that the jury is knowing this stuff about Kathy Griffith?
I'd be very concerned, honestly, because there's also messaging. There's messaging, and it goes both ways. I mean, Collin was very threatening in the messages, but he was also trying to distance himself from his mother oftentimes. In the presence of police, he didn't want to stay there. He wanted to go other places, to relatives. He wanted to even be in a hospital, mental hospital, before he went back. And then the testimony, which is really concerning to me, is that the deputy, the state's witness that's on the stand, this is their direct examination witness, had no idea of these prior instances. And that does not look good in front of the jury, that you have an officer in uniform on that stand saying, I didn't know that she previously pinned her former husband up against the garage door with a car. I mean, very concerning. Now, with that being said, the prosecutor, the best evidence that they have is the fact that the defendant says she fell on the knife, and that knife went in one end and out the other of the neck. You know, so that was a very, very violent stab through the neck that killed her, which really dispels the fact that she fell on the knife. So that's going to be the prosecutor's point one.
Yeah, really great points, David. Thank you for all of that. And speaking of prior instances, we know the defendant said he would kill his mother on a prior instance. Let's play that clip.
Is it a fair statement that the defendant, in reference to killing his mom or his grandma, said, I will kill my mom?
Yes.
And is that when he said that he killed before and could kill again?
Yes.
Don Malarczyk, back to you. You were talking before about how this is an imperfect self-defense case. What does that do, what we just saw, the fact that he had put this out there into the universe prior to the incident in question?
Yeah, I mean, that's a huge piece of evidence for the prosecution to show some prior calculation and design, to show some intent to do this, to dispel any claim that this was an accident or self-defense. And, you know, it's just a really, really difficult case, whether he's found guilty or not guilty. This kid is a deeply troubled kid. This home feels like it was unfortunately full of violence and very toxic. So it's sad, but not incredibly too surprising that we're here talking about these violent acts and all of this tragedy that happened within this family. This is just a really difficult case where this kid really grew up around a lot of violence.
Right. Well said, Don. We're hearing that the jury should be brought in soon as the attorneys are doing some last-minute arguments before the court. And so we'll go there live in our 9 o'clock hour when it begins. Here's a look right now. You can see, if you look really closely, you see the defendant's side profile there. His attorney has been blocking him. Our Court TV videographers say they've noticed this strategic seating going on to keep him out of camera view. I don't know if that's going to help anything because we're not on the jury.